The order regarding a petition for protective order. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine PC, SCAO Form PC 644. SCAO for State Court Administrative Office, PC for Probate Court. This form is a particular form used in a very narrow context, and we're going to explain when it's used and how it's used. With all of these SCAO forms, they are created by various statutes and court rules. And as you can see from the floating yellow arrow, MCL 700.5215 and MCL 700.5314 and MCL 700.5408. And these numbers may not be really meaningful to you, but this is why you really should be working with a skilled, competent probate lawyer to navigate through these types of processes. Now, most people don't even understand what a protective order is and when you'd use it. And we're talking about the narrow context. Think of handling the financial assets of somebody that is alive. This is different than a guardianship, which is for care and well-being, and different than a conservatorship, although the petition for conservatorship is often the basis upon which a protective order gets entered. So the statutes that talk about conservatorship, which relate to the financial well-being of an individual who can no longer manage it for various reasons, you can ask for an ongoing conservatorship, or maybe there's a need for just a protective order for a particular purpose or single event or single use. So let's work our way through the document and see if we can learn more about its context and its use. The top left corner, as I quickly went through, was the county upon which the petition would have been filed and the case number. And with all motion or petition practice, there's a petition filed with the probate court, scheduled for hearing, notice is provided, there's a proof that that notice has been provided of the petition for the protective order. And then after the court makes an adjudication, there's an order that's entered. And in this particular case, the order is for a protective order. Top, it says in the matter of, this is the name of the individual upon which the protective order is being issued. The date of the hearing and the judge, pretty straightforward, intuitive areas to fill out. The next section relates to the findings of the court after the hearing. In this case, the first, number 2, provides that notice has been given or waived as it relates to the interested persons that are affected by the petition. And this is a requirement in all petition and motion practice, that notice has to be either given or waived. And in this particular case, the definition of who the interested persons are defined by statute and court rule. So it's really important that you know who is entitled to notice when a petition is filed asking for protective order relief. Second is that the individual is not in need of a protective order. So this is, in essence, a denial of the relief that the court could enter. So you'd only check number 3 is in the event that the court said, no, we don't believe there's a need for protective order. 4, this is the clear and convincing evidence standard that's required in a protective order proceeding as well as a conservatorship proceeding. And this is the granting of the petition. The individual is in need of a protective order because she is unable to manage his or her own property or affairs effectively due to, and then the list of items. It could be mental illness, chronic use of drugs, detention by a foreign power, mental deficiency, chronic intoxication, disappearance, physical illness or disability, confinement, or other, which is kind of like a catch-all. So it could be one of those, and it could be more than one, but the court has to make an adjudication by clear and convincing evidence that there's a finding, or there are findings, that that person is in need of a protective order. So let's give an example. A protective order would be kind of often used as like a one-off, a one-time scenario. So for example, we're taking the monies that the individual would receive, and maybe we're putting it into a long-term structured annuity. Or maybe it is spent down for a spend-down proceeding for Medicaid planning. It is a single-use order that usually is for one particular event. And to differentiate from a conservatorship, which is the ongoing management of the financial well-being of an individual. So usually on a protective order, it's a single-use event, or maybe it's an infrequent event, whereas a conservator is an ongoing jurisdiction to ensure that the individual's financial needs are being protected, not wasted or dissipated. Now, the second part of the clear and convincing evidence standard requires that the individual has property that will be wasted or dissipated unless there's proper management provided. So it's an and provision here. Or, section B, the money is needed for support, care, welfare of the individual or those entitled to be supported by the individual. So again, this language mirrors the language within a conservatorship statute, but again, conservator for ongoing, protective order for more of a single use or kind of a one-time entry of an order. As we move further down, number 5 says upon presentation of clear and convincing evidence, this would be used for a minor. So let's give an example here where a minor may be involved in a protective order. They are involved in a settlement and they're going to receive over $5,000. And normally, if you receive over $5,000, that money would go into an ongoing conservatorship and be managed by the conservator until the 18th birthday. But with a protective order, maybe the request for relief is that the money is going to be placed into a structured annuity. And it's not going to be released to the minor until after the 18th birthday. Well, rather than have continuing jurisdiction through a conservatorship, a protective order can be entered. So this is an example of maybe one of its uses for a minor. And again, same types of clear and convincing evidence standards under number 5. Number 6, also about the ratification or the direction, authorization of a particular transaction. Maybe a minor needs to sign their name to a purchase agreement for the sale of an asset. These are just examples of where a ratification or authorization may be needed through a protective order. But again, it can be used for a lot of things, even though it's a very narrow context, but it's hard for me to just dream up all the potential uses of a protective order. But as a lawyer who is involved in this space, we know when we want to use a protective order versus an ongoing conservatorship. Number 7, it's in the best interest of the individual that a protective order be issued to authorize, direct, or ratify. Again, this is another example of like a single-use ratification authorization of a particular issue. 8, it is in the ward's best interest for the guardian to sell or otherwise dispose of the ward's real property. So again, this would be used in a guardianship context in which the guardian is seeking single-use authority to ratify, dispose of real estate, to do an action, rather than opening up a conservatorship and having, again, that ongoing administration. The guardian is asking for legal authority to be involved in a particular transaction and get court authority to do so, because when somebody's under guardianship, they lack the authority to address particular financial issues. Number 9 and 10 are the order provision, and here it's pretty straightforward. There's some check boxes for it being denied, granted, or dismissed, withdrawn, as well as this catch-all other in which the court can identify the provisions of that order. Now, often with this scale form, we see this used on a state court administrative office approved form, but often we see these orders hand drafted, and I use the word hand drafted to mean computer drafted. So rather than using the pre-approved form, the lawyer may draft out the document to fully explain, because this form has just check boxes, and often number 10, that other provision, has all sorts of additional orders that we want to include, so there may not be enough room here. So again, you can use the form or hand draft depending on the circumstance. Again, a place for the judge to sign and the attorney's information in the event that there's an attorney involved. So again, this particular order is, remember, the court speaks through its orders, differentiating between a petition and an order. Petition is the request, the order is the relief, the entry of the orders, the court speaking through its orders. As you can see, just by the statutes here and even the language that I'm using, guardianship, interested persons, notice, protective proceedings, conservator, these are complicated issues. And again, we strongly urge you to be working with a skilled, competent probate lawyer who knows how to navigate through these particular issues through the probate court. At the Probate Pro, we are passionate about everything probate. If you have a question on this particular form or any probate or trust related issue, visit us at probatepro.com or call us at 1-833-PROBATE.